LGBT Chambers of Commerce. And I know Tammy just wrote in the chat, Tony's working to get this set up to where we're broadcasting through another one of his venues. So if we run just a little bit late so that we make sure that we've got all our broadcasts going on, I'll certainly be the most forgiving when it comes to making sure technology is doing what it's supposed to do, because that is absolutely not my strong suit.
This is wonderful, though. I mean, I confess, when we were thinking about doing this several weeks ago and y'all invited me to present again, I was thinking after the last one, which I thought we had a very robust response, because things had calmed down a little bit, that perhaps this one wouldn't have the same fervor about it, if you will, that the last one did. But golly, with what happened Monday, well, I won't get ahead of myself, but that's just, I don't know, you know, with the trouble right now, we're not hearing as much about what is wonderful about that decision. But that is my talk today. And if we don't even get to the rest of it, I hope y'all don't mind. Now, are we recording this, Chase?
The recording has begun.
Okay, great. Well, that's good, because even if we don't get to the end of this, because this, before the wondrous decision on Monday, was a much more, I don't want to say routine, but it was going back to work. That was the name of it. It was good, solid, substantive, but not hallelujah type advice. And I don't know if I want to spend, if we got some time, great, and I will devote myself to it. But really, the things that have just happened are so remarkable. Many of our listeners are young. I wonder if there's even anybody listening older than me. Hey, we can have, who is the oldest buzzard on the block contest?
Does Title VII include age discrimination?
Not if I do it. Well, that's interesting. When we run ads, that's not part of the talk today, to invite people to apply as an attorney. And I retained outside employment counsel to be sure I was right about this. You can say that you want to hire mature people. You just can't. If I said must have 25 years as a licensed attorney, well, that absolutely, just like a medical doctor, a CPA, a financial advisor like you, by the very nature of it, that person would have to be in their 50s. But you cannot say must be in your 50s. You have to, but you can say must have X number of years of licensed experience, even if it has nothing to do with nothing, because what you really want is somebody who is older and more established. You know, they know what they want. I hope most people. How old are you now, Chase? Like 19?
834.
Yeah. No, that's me, buddy. You know, how many, lawyer years, trial lawyer years are like dog years. So that makes me 40 times 7 plus 24.
Well, in fun legal trivia, if there is such a thing, it is okay to age discriminate in housing. Isn't that right? Do I have that? Am I close?
Housing?
Like I can say I want to rent my place to people who are 55 and older.
Well, Chase, that's a question I don't want to answer.
And it's a question that has nothing to do with what we're talking about. It is time for us to get started with our webinar. So let me begin by introducing myself and our organization. My name is Chase Kincannon. I'm the board chair for the Austin LGBT Chamber of Commerce and a constituent member of the Texas LGBT Chambers of Commerce. We're joined today by folks from all across the state of Texas as members of the Texas LGBT Chamber of Commerce, which consists of the Austin, Houston, DFW, and San Antonio chambers. Welcome to all of our sister chambers. We're very excited to be hosting this webinar for you today. We're going to cover a lot of ground. We have an hour and a half scheduled, and the first hour or so is going to be Ms. Fowler pontificating, and we'll save the last half hour or so for Q&A session. By way of the chambers, I wanted to mention the Texas LGBT Chambers of Commerce are a relatively new entity that came about in time for the 2019 Texas legislative session. In 2017, because of the bathroom bill and associated issues, it became incredibly apparent that it was high time for the Texas LGBT Chambers of Commerce to band together and unite in a front for advocacy to help LGBT business owners and their allies make sure that they were represented at the state level. And as a result, in 2019, we had our first advocacy day, advocacy platform, and joined forces with multiple organizations across the state of Texas to make sure that our members' business and social interests were represented and defended during the 2019 legislative session. We're really proud of all the work that came together so quickly to make so much get done and to keep a lot from getting done, if you know what I mean. And we're looking forward and gearing up for a 2021 presence in the Texas legislative session. Each of our member chambers has an advocacy committee that works to help develop platform that needs to hear from you. Our members are where we derive our passion and our power, and we need you to become involved in our chambers, whether you're part of the Austin, San Antonio, Houston, or DFW chambers. Get involved, join the advocacy committee. It's a great place to make sure that your voice is heard, that your business and personal concerns are heard, and that you and your business and its organization is represented in the state capitol. Also, on the local level, we do advocate with city council and with the county to make sure that Austin is as, for Austin, is as business friendly as it can be to the LGBT community. We're fighting for good change. We're doing an incredible job of it, if I do say so myself. Contact information for any of your chambers, if you want, we can put it in the chat box. The other thing I want to mention before I introduce Ms. Fowler is that, of course, everyone, I hope, is aware of the monumental Supreme Court decisions that have come out in the last week. On Monday of next week at 5:30, we are hosting a webinar, which will be a panel to discuss the impacts of Monday's Title VII ruling. One of our advocacy committee members, Gary Schumann, who is in charge of the Texas, the LGBT section of the Texas Bar, has put together an incredible panel full of really heavy hitters in the Texas legal community to have an open discussion about what this decision means and how it impacts us. I strongly encourage you to join us Monday at 5:30. I'll post the link for that discussion. It's going to be really great. It's been in the works for a very long time. Of course, we're very pleased about the decision, but there's a lot more to be done, and you need to know about it. With that, I'd like to introduce to you Ms. Laura Fowler. She is the chief, I'm going to screw up your title, shareholder of the Fowler Law Firm, which has practiced law in Austin, Texas since 1857. And doesn't she look good? Ms. Fowler is a long-standing member of the Austin LGBT Chamber of Commerce. She is one of the founding sponsors of the Texas LGBT Chambers of Commerce. She is a supporter of the LGBT Chamber Foundation, which provides scholarship money to upcoming LGBT entrepreneurs and business people, and is a local expert and also provides pro bono counsel to the LGBT Chambers of Commerce. With that, we're very pleased to have her come and present to you. She's one of our favorite presenters because she's so loquacious and entertaining. And she's very gifted in the department of making something that, if you had to read about it, would be a quick snooze into something that's really exciting. So with that, I'll turn it over to Laura and her unabashed praise for how the Chambers of Commerce have benefited her and her organization, and how I can do the same for you. With that, everyone, please welcome Ms. Laura Fowler.
Thank you so much, Chase. And let me start with a little background here. We did a webinar when everyone, I think, who was being honest, was terrified. Back in late March and early April, we did a webinar, and I forget what we even called it. I think it was Coronavirus Straight Talk for the LGBT Chamber. But it really was to just try and bring some hope and an ability to look forward. And it turned out to be a great talk. And I think everyone enjoyed it. It was very interactive. And then when I was asked a few weeks ago, and I, of course, would anything that I'm honored to be invited to participate in for us in LGBT Chamber, I gladly do. But I confess I was thinking, well, there's a lot that's useful to learn. And kind of that category Chase just talked about, the important snooze factor stuff. But when what happened on Monday, and I want to say to you, I'm going to just assert a point of privilege here. I'm 65 years old. I've been licensed as an attorney 40 years. Obviously, in 40 years, the U.S. Supreme Court has issued a lot of decisions. But I think for a lot of reasons, and I'll also tell you a little of my background, which may not even be very well known. I'm not a labor lawyer representing workers who have been harmed and wrongfully terminated. All of my career, I have represented institutions. I have the privilege to represent LGBT Chamber, that's an institution, and governmental units and universities and private employers. So I've always been on the defense side of employers, and I've done a lot of that kind of litigation. For years and years and years, I have been in the courts trying these cases on behalf of employers. And of course, a whole lot, probably half of the cases I've tried over the years have been classic Title VII violation of rights alleged by workers and protected classes. And of course, all through the years, the rules changed and the courts changed. But what I want to spend as much time as I need to spend developing today, and then encourage you all to go to this great seminar on, is that Monday, Chase, with Gary Schumann?
Yes, ma'am. Monday at 5:30.
Learn what this means, because unlike the Civil Rights Act of 1964, and it was actually the amendment in 1971, I've heard so much nonsense on the TV set since this all started a few days ago, because if the reporters had spent some time reading the decision, which we're going to do today, as opposed to just reading headlines somewhere, maybe some people would learn something. But what to me is so powerful is how clearly this decision incorporates our entire community. Unlike the waffling and weaseling that the Civil Rights Act of 1964 and 1971, and I will tell you this, I would not have the privilege to be here doing my, what'd you call it, sermonizing, pontificating, Chase, if it hadn't been for the Civil Rights Act of 1971. But by, let me see, 1976, when I entered law school, there were exactly 5 women in the whole law school. And today they're roughly half. Now, roughly half of most law schools are admitting women. But my point is simply this. A lot about those laws in the beginning was unclear. There was a lot to fight about. So that whole foundation of, in your case, almost 50 years of fighting over the term sex and over the term right to be employed and over wrongful termination, which is what this profound decision is all about, wrongfully terminating someone on the basis of their sexual orientation. Every bit of that is very clear in this decision. I have a hard time seeing what there would be to fight about. And that is simply wonderful. In a way, not many decisions are that wonderful coming out of the U.S. Supreme Court, other than for lawyers like me, because when they're ambivalent, then there are more cases to try. But instead of listening to me, I have the case here. Unlike the TV set, you're going to read some law today. And when you exit this talk, you're going to know more than a lot of lawyers, because there's been a lot of nonsense said in the last 5 days. Now, I just got to show you this, because this is my law firm. We haven't all been together in almost 3 months. I just get kind of choked up when I look at all of them. But anyway, there we are. And this is going back to work. But we may not get to going back to work, because we're going to get to this decision, which just is so wonderful. I'm just going to spend some time talking about it, whether you care or not. So, and it's my
Tell us who the exceptionally tall man in the back row is.
I'm sorry. Oh, dead guys, Chase.
Exceptionally tall man in the back row.
Tall man is Judge Robert Lee Penn. He died in 1909. And then let's see if I can get the pointer up here. There's ID Fowler. He entered University of Texas Law School in 1894. And in those days, by the way, in 1894, you got a law license, or you were eligible to practice law in 1 year. It was a 1-year degree. So a lot has changed. So, okay, now, oops, what have I done here? It's not advanced. There we go. What are we going to cover today? Well, we're going to really try and cover some things today. But after I got through making up all this other great stuff that I was going to talk to you about, I think this, woohoo, and yeehaw, legal, this is more important than all the rest of it. Now, you're going to get the whole PowerPoints and the recording, and if you just can't get enough of me, you call up, and at no charge, I'll give you the whole tutorial of what these other points are, because they are important. Like Chase said, major snooze factor, but this first one, there's nothing snoozy about this next one. All right, here's stuff that I am not hearing on the TV set that I think is very important. First of all, this is the case. Now, it wasn't just Bostock versus Claycomb County. That was one employer. But usually the U.S. Supreme Court doesn't take cases just because they think they're good facts. They take them because there's a dispute among the circuits. There was a pretty significant dispute. In other words, in some states, you couldn't fire someone. It was federal law that you could not fire someone on the basis of their sexual orientation or being transgender or any of the protected categories. In others, sex, and the Fifth Circuit, Texas was still one of them, was still interpreting that as sex meant something that did not embrace sexual orientation, transgender, or any of what we think of as protected classes. So there was, but as of, just like there was a difference among the states about whether or not same-sex individuals could marry until 3 years ago, the U.S. Supreme Court picked that case up because there was a difference among the appellate courts. The same is true here. Now, what I think is very, very significant, you hear a lot about 5-4 decisions. Just this morning, DACA, which many people have been following closely. Apparently, there are more than 600,000 people in the United States who've been here since they were very young, who faced possibly being sent back to countries they didn't even have any conscious memory of, where they have no family or friends, but for the ruling this morning from the U.S. Supreme Court, and that was a 5-4 decision. But this one on Monday, what I think all of you have much cause to rejoice about is that it was a 6-3 decision. That's unusual for this court. And here are the justices that decided with the majority. First of all, Justice Gorsuch, who was appointed by President Trump, wrote the majority opinion. And then I'm not getting into the politics of things here. I'm just saying, I don't think there's much dispute. Justice Gorsuch is considered a very conservative justice, so this surprised a lot of people that he wrote the majority opinion. Then the Chief Justice, appointed by George W. Bush, Chief Justice Roberts, sided with the majority, and this is why it was a 6-3 opinion. Why I make that point is, politics aside, when you see this sort of decision, that I take great joy in the realization that these brilliant men and women, whether you like their politics or not, those who sit on the U.S. Supreme Court are among the most brilliant lawyers in the United States. They are individuals who have remarkable qualifications. Politically, they may be of different beliefs, but they are remarkable jurists. And that we had a decision like this with the diversity of political and other types of beliefs of these judges, and they all ruled in favor that everyone has a right to go to work and not be wrongfully not be terminated on the basis of their sexual orientation or gender. That's a remarkable decision. That is a cause for joy, because very conservative justices transcended party and political belief and did the right thing. And it, in this time of so much trouble and controversy and violence and everything else, that we could Monday morning have something like this come out, it gives me renewed faith that the world and the United States, there's great hope for us. You should be very, very proud. This is something your organization's worked for years, for 50 years when you get right down to it, because in 1971, the Civil Rights Act of 1964 was amended to include sex. And I think you'll find the syllabus and the decision, which is right at 157 pages, very interesting to read, because it does touch on the whole history, how much less the issues, LGBT issues, transgender issues, were known in 1964 and in 1971. Nevertheless, civil rights for all, for every citizen in the United States. And this gets back to one thing that I think if all of us, no matter what we believe and how we vote, can accept, that we live in a nation that is governed by a constitution that is a remarkable document. And ladies and gentlemen, this decision on Monday is one of the finest examples of how that constitution afforded to you what in many nations, many wealthy nations, would not be your rights. It took 50 years to get there, but you still got it. So hoorah. Now, here's something that I have not seen, and that's because, you know, on TV, they don't want you to read because those headlines are so much sexier, but here's the law. And this too gives me great joy. And I'm saying this to you as a trial lawyer for years and years and years. If you want to know how these lawsuits work, Chase, I may just take a moment, because it's a little different than somebody ran into the back of me with their 18-wheeler type lawsuit. When someone alleges that their civil rights have been violated in employment, it's sufficient that they take the witness stand and say, I was adversely impacted in an employment setting, fired, demoted, pay changed, duties reduced, benefits taken away. It doesn't have to be fired. Now, this is a lawsuit about wrongful termination, but believe me, the way this has been worded so carefully by these justices, this is as carefully worded as any decision I've seen. There's no ambiguity in this decision, and it is all favorable to you. So, but once the worker gets up and says, I lost some benefit as an employee, or got fired, had a benefit taken away, and I fit into a protected class. And by the way, everything that was decided on Monday, and everything I'm going to say today, applies with equal force to all the protected classes. It is merely that you now are unquestionably, without any ambiguity, in those protected classes, just like race, ethnicity, faith, your party affiliation, or gender. Yay! All right. But here's what's very, very powerful about this. It is an employer violates Title VII when it intentionally fires an individual. And I'll just tell you right now, taking away benefits that just wasn't the case, the facts in this case. It will apply in the same way though, based in part on sex. Well, yahoo! Because one of the toughest things for an employee to prove always was if you had to prove up that the employee fitting into one of those protected classes was the quote unquote producing cause. Here, you only have to prove up that it was one reason, in part on sex. Now, this was what they call a nice clean case, because the employers didn't dispute that they discharged these employees because these employees openly identified as being, in one case, transgender, and in another, a homosexual, a gay man. But it didn't even have to be that clear cut. It could have been just in part based on sex. So that's very, very powerful. And then it goes on again, and it makes the point here, homosexual or transgender, that they both are included. There's been some debate over the years about whether or not transgender actually fit into this. But this decision, I mean, there is no higher court of appeals. Well, depending on the deity of your choice, but that's between you and your deity. This is it. This is the final arbiter of everything. And it's all here. I just get so excited. It takes a lot for me to get excited enough to even read one of these 151-page magnum opus, but I guess that's opie. What's a plural, Chase? Opus is opie? Opia? Opias, opiatum. Okay. All right. Now, on to the next. This just gets better and better. You're going to love this stuff. Now, when is Boston? And this is what you need to go. Because, you know, a lot of you probably fit into these protected classes, and you're also a supervisor or a business owner. And you need to go to Gary's talk and list all those people next week. I would not say it went into effect Monday, because that was actually not the final. They still have a right to take people's comments, but, you know, they just love getting every period and punctuation mark right. So it's still not a quote unquote final, and it says that on the decision. And that's a technical point, but occasionally somebody will say something that moves them enough, they change something. I doubt that's going to happen, but it isn't enforceable yet. But I would say, if you're an employer, if you're a supervisor, ladies and gentlemen, start your engines, because this is not something that is delayed in its enforcement. Now, here's the next part, and this is the part I want to talk to you about. Value added that maybe nobody else is going to talk about, but I would like to tell you that we are all evolved citizens. So when the highest court in the land, the U.S. Supreme Court, says, "Thou shalt not discriminate anymore," everybody's going to say, "You betcha, sister," and just go right off and do right. But since I have made, frankly, a very good living for almost all of my 40 years, because I began as an American naval officer defending the United States Navy with all those exhilarating allegations. But, you know, if you want to give somebody a 1-2 punch in the belly, that frankly, for a lot of people, is a lot more powerful than saying, "You violated my civil rights now." All you need to do, and also because, well, I'll just get to this in a minute, but it's an interesting observation because it's not as well known, and yet I think it's a great deal more powerful. If you go after, and I don't want to name any names, but just one of the big corporations that I'm sure they all really try to do right, and they have enormous pressure on them to do right and afford to all the protected classes, what the U.S. Supreme Court and the EEOC have promised to all of us as citizens of the United States. But if you sue one of those corporations saying, "I represent a worker whose rights were violated under the EEOC and civil rights protections," you know what they're usually going to say? "Wow, take a number," because there are like 5,000 other people that are suing them all over the United States. A lot of these are global companies. They're almost anesthetized, that kind of stuff. But let me tell you right now, my friends, these same companies that are so big, they are, many of them, most of them, either they are direct government contractors of the United States Department of Defense and United States federal agencies and state agencies and local government contractors like the city of Austin. And their purchasing agents are very aware of their duty to debar contractors who violate somebody's rights. And I don't know why more representatives of workers don't use this as a 1-2 punch. Sure, you need to go file a lawsuit and exploit whatever the human resources protocol internal, which you got to go do. You can't just go file a lawsuit in United States District Court. You have to go through the entity, and then you have to go over to U.S. Department, the EEOC, and sometimes other departments before you can actually even have a right to file in the United States District Court under Title VII. But this thing where you tell them, it ain't over, my friend, because as a contractor, I'm going to get you because you are violating all these people's rights, and you're rather cavalier about it. And that is where you can really frighten some people to death. Now, I urge you to only use these powerful weapons when what you have to say is true. Don't just go making up stuff to get what you want. That's wrong. But where you see somebody, and usually it's a fairly low level where sexual harassment occurs. The days when these large multinational companies could afford systemic discrimination across an entire body of hundreds of thousands of workers, that gets expensive in a hurry. And these big businesses have been sensitized to it. But the idea that somebody is going to do what's called debar, if you go, and I'll pick on Austin, let's just go right to it now, because so many people don't even know what I'm talking about. Okay, I live in Austin. I know you are listening from all over Texas. Many cities in Texas have this very same wording in their municipal code. Here it is. And Austin, long before this decision on Monday, had for some time protected not just the traditional race, color, religion, sex, but sexual orientation, gender identity. So for a long time, and that law actually goes back to 1992. That's how long that law has been on the books as municipal code. This is a criminal law in the city of Austin. It's a misdemeanor, but it is a criminal law. Now that's pretty powerful. You know why? Because when you violate a criminal law as an employer, you have to report any charge or citation that's criminal violation to your insurance company. Because when you make people spend a lot of money, they pay attention to you. It's all about money. I'd like to say we're all evolved. It's all about doing the right thing once you beat somebody with a baseball bat once, but it's about money. And having people convicted of these misdemeanors, if they own a business, small or large, it has enormous consequences. Now, same thing here. Okay, what am I talking about? There you go. See, 1992. That's how long this law has been around, protecting these classes. Austin's been very evolved for a long time. Okay, now here's the biggie. And this is a much underutilized section, but it is in most of the city codes that I have dealt with. And that is, these contractors, if you want to get your $50 million contract to go build a sports stadium or whatever City of Austin's handing out this month, you have to attest that you do not discriminate. And in the City of Austin, that discrimination includes sexual orientation and gender identity. So if you're a worker or you're a lawyer and you start proving up that your client has been discriminated against, and notice, I'm not talking about by City of Austin, I'm talking about somebody who makes money from the City of Austin, who sells them towels, who chops down trees, who installs utility grids, who makes millions and millions and millions of dollars getting these yummy, delicious city contracts, which are the heart and soul of a lot of businesses that are just discriminating up a storm. And the same people that you tell them that you're violating my client's rights stuff, they don't care. This is going to be a long time before the train leaves the station on that one. You tell them, I'm going right over to purchasing. I'm going to tell on you because it is not right what you're doing. I think you're going to find through these sections, and again, Dallas, Houston, Most Texas cities have something similar. It's just people don't understand how to exploit it because they do not understand local government code, purchasing, and procurement. Now, if I had any guts, how long have we been talking here? I would just say, I love you, savor this, goodbye. Because this is so powerful. I've just delivered all of you the keys to the kingdom. If you want to set somebody's toenails on fire over there in some city that is given some juicy contract to some contractor who's discriminating against people, this is it. Where they construct sewers or have a gigantic $2 million food concession over at the sports stadium. This is it. And if you look into many of all assorted sizes, including people who are themselves qualified as historically underutilized business, if they are discriminating on the basis of a protected class, they are particularly vulnerable because in addition to getting debarred, they can have their historically underutilized business status pulled. That's like the trifecta. Okay, Chase, I'm tired. Can I quit now? This is so good. It's all downhill from here. I got no more ruby slippers to give out.
You spent all your energy and didn't even get to what the topic is.
What is it? Oh, going back to work. Well, going back to work and soon,
just 1 second. I do need to give a quick Chamber of Commerce commercial for everybody who's listening. Your portal to LGBT BE Business Enterprise Certification is your local Chamber of Commerce, your LGBT Chamber of Commerce. We are the organization that certifies your business as LGBT owned so that you can become part of this procurement process that Laura is talking about and get a leg up. So even if you don't experience discrimination, and you're not able to file one of these big fancy lawsuits, you can still get your company certified as an LGBT BE, which in many cases will get you favorable treatment in the procurement process. To learn more, contact your local LGBT Chamber of Commerce leadership. Back to you, Laura. Thank you.
Very good, Chase. Yeah. Now here's the problem, though. I gotta tell you a funny story. I just love those certifications. Can I brag a little? I'm proud of this. All right.
Please.
The city of Austin has a wealth limitation. So after you get this certification, and I'm going to tell you right now, most years the city of Austin, which has a mandate to give out a lot of money out of its budget. I mean, it's got a percentage set aside ordained by the city council, including most especially for LGBT, just like Chase just said, LGBTQ. And the problem, though, is if you meet that wealth cap. In fact, I got this nice little sideline business now with these people that I'm just so happy. Some of them truly were the working poor. They really were. And they plugged into one of those historically underutilized business categories for the city. Most of these people, a lot of my work is employment, and then a close second is construction and real estate. And a lot of these contractors that fit into a minority category or protected class category. And by the way, if you are in construction and you are LGBTQ, you are rarer than a dancing zebra. So you need to go get Chase's certification there, and gold will flow from the heavens because they must give these contracts out. Now, it is helpful if you know something about building before you start getting these contracts, but details, darling. Anyway, but yes, but when you reach a certain wealth limit, which in Austin is a little bit more than $1 million, then you can't get the contracts anymore. And that's when you come see me, because I have creative alternatives to all this. But I'm glad you brought that up. I always forget to bring that up, Chase, but it's an incredibly valuable in the city of Austin, and many of our other larger municipalities in Texas have that too. So good point. All right. Now you can all go to sleep or go back to playing on your cell phone or eating your lunch, because the rest of this is useful, but napping might be more useful if you got up early. But these are all things that every last one of them, nobody calls me. I'm like the emergency surgeon. Nobody is calling me to do something happy and proactive. They're calling me. This is about as happy as proactive as anything I do. They call me because they're about in a fisticuffs in the personnel office or something. Now, let me just tell you this. The next couple of slides, so I'm going to move through this very quickly, are all about, you've all probably got employee handbooks. And in that employee handbook somewhere is a definition of how much leave you've given people. In Texas, with a few exceptions, like local governmental units, where there's a statutory mandate, teachers would be a good example, police officers have a mandatory minimum leave. Texas does not require an employer to give leave, but most employers give some paid leave because they wouldn't be competitive if they didn't. So you got to remember in coronavirus that your pre-existing leave is a foundation upon which the new special and much shorter in duration entitlements exist. And I just want to say this, I'm going to take up a lot of time about how all this works. You cannot answer anything about coronavirus mastering coronavirus, because nothing about coronavirus stands apart from what you as employer have afforded in your basic leave. If you're over 50 employees or full-time equivalents, another complicated analysis, you must provide Family Medical Leave Act, which is a form of unpaid leave. And you may have afforded paid leave on top of that. Under 50, many employers do because they see it as a competitive tool. They don't have to, but it's a retention tool to get great employees. But I just beg you, when an angry, frightened employee comes in and says, I'm not getting my rights, and my supervisor wouldn't give me my rights, and he isn't right, and you just need to take away today, ladies and gentlemen, is leave is wages. And if you don't treat leave just like wages, there's no such thing in Texas as compensatory time, with a few exceptions that are governmental units and certain faith-based organizations. But mostly there is no compensatory time, and leave is just like a day the man or the woman worked and put in their 8, 10, 15 hours. The penalty under the Texas Payday Act and the Fair Labor Standards Act, which applies whether you got 1/2 of one worker or 500 workers, is $1,200 per worker per week. Now, if that doesn't scare you half to death in terms of something you don't need to be fooling around with or hosing anybody around with, I'm not a very good lawyer. But I tell you this, leave is wages, pay is sacred. I have had many clients that had the U.S. Department of Labor, because the U.S. Department of Labor concluded they were doing it deliberately for people who were minimum wage or only slightly higher. And the U.S. Department of Labor came out, and for the a few $10,000, $20,000 owed in unpaid wages, they imposed a fine on this $1,200 per worker per week category of $500,000 or more. And it's not covered by your insurance either. I don't care how great your D&O is. Fines and penalties and unpaid wages are rarely covered under any of these great insurance policy you paid all this money for. Are you scared yet? Leave is wages. So you need to learn what your leave is before you tell anybody yes or no. Where did these policies come from? Now, if you just can't get enough of this wonderful stuff, I will talk to you forever about how you need to put your policies on a weight reduction plan. And down there at the bottom, if you're just sick of your morbidly obese employee handbook, you need to go to the Texas Workforce Commission. And I don't make any money telling you to go there and look at their very skinny, about 30-page document that is just fine for probably about 99% of you. It's easy to read. It's what the state of Texas tells you to do. You can plug in your leave and a few other things and you're there. As opposed to these nightmarishly long, ambiguous things that somebody like a payroll service gave you for free. But believe me, that was the most expensive freebie you ever got. Now, has everybody put up, there's still a lot of our clients that haven't come back to work. Did you put your poster up? I think the Family Medical Leave Act Division of the U.S. Department of Labor actually did a pretty good job of writing something that made sense. Don't guess. download this poster. There's the link right there. When you're talking to the angry employee who's screaming and yelling because he's not getting the leave he thinks he's entitled to, give him a copy. Read it together. It's like scripture reading. The more you read it, the deeper and richer its meaning becomes. And then you'll know what to do. But again, there are two parts to it. There's your employee handbook has promised people things in the form of leave. And then this coronavirus has promised them leave. And it's not just if they're sick. Okay, last thing, if you're the employer, even if you're a nonprofit, this doesn't cost you money if you're able to continue to go on, because you get dollar for dollar credit for every dollar you are paying under this coronavirus entitlement. You will be able to take a dollar against employee payroll. It's not against federal income tax. You know, a lot of us are going to declare a loss this year, most of us possibly, but payroll tax is different. So this really is free as long as you continue. You're just advancing sick leave pay as long as you continue to have employees. So that's a win-win. Okay, when may the worker refuse to work? Now this is hot off the press from the Texas Workforce Commission. We're going to send you this whole thing. I'm not going to take up 5 minutes reading this to you. This is a lot of stuff. This is stuff that could potentially go through till the end of the year. Now, but this thing that's hotly debated right now, workers who are earning more at home than they would be earning if they return to work, that will all end at the end of July unless Congress passes a new law. And then Texas will return to where it has traditionally been, which is characterized by many as one of the stingiest on employee benefits. So there's not going to be this enormous incentive or temptation for people to stay at home. But I'm just going to tell you something. I find most employers to be too loving and too trusting. And I'm an employer. I employ 26 people. I love my people. They're like my family. But at the same time, you know, trust, but ask for something to support whatever it is they're telling you. If they say, I got grandma, Abuelita, I got to stay home with Abuelita. Well, great. Have you ever seen Abuelita? Get something to prove up that Abuelita's there and that she actually lives with that employee. People are going to exploit this because for some people it's more fun to stay home. Now, the next thing, let me tell you, don't make this mistake. If you tell somebody, okay, you can stay home and do your duties, you have not changed anything and they're entitled to full pay and benefits. You have to do these things in an orderly way. You're not doing them a favor legally when you say you stay at home and I'll pay you 2/3 of what you normally get. If you're going to do that, you need to discharge them from one set of duties and take the steps that your employee benefit requires for you to transition them to another set of duties, another amount of pay, another hourly wage, whatever you do. You cannot afford to be casual with this. Why? Because it's wages. So here are all the new Workforce Commission reasons that they don't have to come back to work, but get some verification. And also daycare and schools are now coming back online. So this is not all everybody gets to stay at the house anymore. A lot is changing very quickly. Now, some of us have loved ones, friends, and employees who fit within these categories. H-1B, Austin is a big high-tech town. So are some of our other cities who are listening today. We have a lot of people in high-tech who have been in our cities literally since they graduated from college. They're brilliant people. They're cherished workers. And now they're dealing with these heart-wrenching situations. This is not DACA. DACA was decided this morning. This is people who are here on H-1B visas who got laid off, skilled workers. Do everything in your power if you love these people and you can afford to extend them for as long as you can and work with them, because those people are in a heart-wrenching situation. They've only got 2 months to go find something else to do. When somebody calls me and says, Laura, can you get them another job? I say, another job in what? Well, you know, like the one I gave them. And I say, it begins and ends not with the law. It begins and ends with what their visa said. And don't be fooling around either. Most of these workers, they have that visa. It's in their wallet, it's in their glove compartment, it's everywhere they go. Their most current visa has definitions of what they may do, and it is not a one-size-fits-all visa. But they're going to have to, within 2 months, find other work that conforms to the definition of that visa. And since they got laid off en masse, most likely, that's not going to be the easiest thing for some of them to do. Now, we're advising everyone, but do not, this is like performing neurosurgery on yourself. They need to go get some help. And there are plenty of people, certainly in Austin and in San Antonio, very skilled in these areas who will help them as part of their pro bono outreach. But they need to get some help if they're going to try to simply convert into a tourist visa, because that's not the best place for a skilled H-1B to be. Now, H-2B, H-2A, those are foreign worker visas that are by their very nature cyclical. Many migrant farm workers who our firm does a lot of pro bono work with, and a number who are housed here, that's typically the H-2As. They have been permitted, if they are already here, to stay, which has proved to be excellent, because the people who were supposed to come up to replace the ones that had to go home, because in these H-2A and H-2B cycles, they have to go home. There are none of them left. So we've got acute labor shortages in some of these. Farm workers, we got labor shortages, agricultural workers, clothing workers, hospitality, maybe not so much hospitality, some limited areas in rural areas. But anyway, stay on top of this if you have this problem. And let's be kind to these people. Now, I could take up another 10 minutes talking about this, and I'm not going to, because you're going to get this. And then if you got any questions, you just call me at no extra charge, because I just love to talk about this. Nobody ever calls me to review their contract, which would be really cheap, and we'd have a great talk, and I write comment, and it's really professorial, because I love contracts. I love all the way brilliant people trying to cheat each other. That's what a contract is, by golly. But sorry, I was carried away there. But these are the Big 10 that my wonderful friends, including my brainy, brilliant, high-tech people, a master of the universe, and other people, wonderful people who are so good at what they do. And I submit, of course, I only represent people who are wonderful. My clients really are very, very good people, and Austin is filled with remarkably good, kind, brilliant people. However, I think it's the very people who are honorable and who are good and who are kind that have a hard time believing what monsters, AKA people like me, would write these contracts. So here's the Big 10 of the terrible things the monsters do with foreign contracts that may have come out of halfway across the world. But these are the mistakes that get made over and over again. I'm going to tell you, somebody did a lot of business and a lot of construction, high dollar deals that these contracts were involved in. It's not something really exotic, like when the server in Chicago or the thing in the cloud shoots a zillion bits of data halfway around the world and it didn't work. That's not what we get in these fights over. These are more fundamental fights, and they're much more difficult. Like, nobody in a position of authority even signed the thing. Who are these people signing? And any authority? Or my favorite, they're all broke before you sign the contract. Why are you letting your money, hundreds of thousands of dollars, fly through the air to something that's already broke and has got IRS tax liens in like 30 seconds? After you get familiar with the sites, in 30 seconds, and I've given you a link, you don't even need to read past number 1. Late at night, alone and lonely, if you just can't sleep, you can find out everything about your neighbors for, let's see, number 1, the Secretary of State. You'll find out everything your competitors are doing there for $1 a search. What a deal. DPS, same thing. And then the property search. Who wants to do business with people who don't pay their taxes, right? You can find out who's paying their taxes, who's been naughty and nice. how do I know my clients don't do this? Because if any of you ever send me anything to do, before you ever walk in the door, I've done this on you, Chase, don't worry. You do a very nice Google, my dear. You pay your taxes and you are who you say you are and your licenses are good. But many people aren't. So check it out and maybe you won't be as eager to let $10, $20, $100,000 go flying through the air. And right now, in the aftermath or the coming out of this coronavirus thing, there are many wolves. Now this, and I knew Chase was going to be my host today, so I did carefully check all his licenses. You're good, Chase, don't worry. But this is another one. Unfortunately, there are a lot of people, you know, we want to be optimistic here, and I am eternally optimistic that we live in the greatest state on earth. And I'm going to come out of this, and everybody eventually is going to, the ship's going to right itself. But there are a lot of people that, you know, if you're going to buy food and put gas in your car and pay your auto liability insurance or pay your professional license fee, what's it going to be, folks, if you don't have enough money for all of them? And there are many people, and I'm seeing an upturn in this, who have let their licenses go into suspension because they just didn't have enough. Well, okay, if you let that happen to you, every time you sell a service, if Chase lets his license go into suspension, then he sells a licensed service, such as a security or a insurance product, that's criminal misconduct. If I let my license go into suspension, and then I try to sell you legal advice, that, or actually in the case of lawyers, did you know, even if we give out pro bono legal advice, if we don't have a license, it's criminal misconduct? Isn't that exhilarating? Just opening your mouth gets you in trouble if you're a lawyer. But all right, so every one of these people you're doing business with, these searching, it's all published. If you just know what kind of license a person holds, Chase is Texas Department of Insurance. Me, it's the State Bar of Texas. So please, on your own license or certificate, keep it current.
And as everyone scurries quickly to Google my TDI and FINRA licensing, I wanted to let you know that we've got about 5 more minutes before we start doing Q&A.
This is so great. Look at those seals, Chase. Aren't those just the most beautiful seals on earth? Yeah, well, all right. I just love doing this. Do you know how I can torture whoever it is? Somebody hires me to sue. I just do these 5 little things. I can torture most people to death because people aren't careful about this. That's what I do. All those hateful things you never wanted to do because you're a decent, evolved person. Here I am, and others like me, affordably priced. All right, I'm moving on, Chase. Your brand. Now here's another one. Trademarks, domain name, all those things. None of those cost very much. Go check them and bring them current because those are very, very valuable. If your domain name goes down because you didn't pay that little GoDaddy fee, or what is it, $9 or something, that's terrible. That's disastrous. And then if you get sick or die, well, we won't talk about that today because everybody's gotten well. I hope nobody suffered from coronavirus. But do remember, as I think you've all now learned a powerful lesson, we are not invincible. Many of our loved ones who weren't necessarily extremely infirm or elderly. So have a plan and have your estate plan and documents in order. And because this is a going back to work talk, have that business succession plan. And I can't think of anyone better to talk about that than Chase Kincannon. His observation about business succession and how to structure it is superb. And then last, and this always is a wake-up call for somebody listening to my talks, many of us have done a lot more driving since coronavirus, and we've asked our employees to drive too. A lot of people don't understand, even if your employee is in full compliance with state law, which is 30, 60, 25, those are the minimum amounts you must have to not be violating state law when you drive an automobile. If you ask your employee, for that matter, you drive an automobile owned by yourself, privately owned, not owned by your business, your private or personal auto liability insurer has the right to not cover an accident that occurs in the scope and course of a commercial mission. Now, these insurers, they want to keep you happy. And they're very accommodating. Usually it takes one call to the insurer and you tell them, hey, my employer started asking me to drive 20% of the time I use this car now in my business or in his business. And I say, okay, got you covered. And about 5 seconds later, you'll even usually get an electronic confirmation. Please do that. If you drove here from work today, well, you're all at your, wherever you are. But another thing though, is so many people are now at the home and working from home. If your home is your office, you get in that car to go do the scope and course of your business. All of that's going to be commercial when before you got in the car to go to another place and only from there. So the amounts you're driving may actually have increased in the commercial part of your life, may have increased quite a bit. So enough about that. Okay, we are wrapping up here, Chase. Bonus, yippee! All right, now you are probably going to think I'm going to tell you that what you need to do is go get a great lawyer like me. Well, that's up to you, but that's actually not where my finale here. I think every one of us who ran a business or was managing a business has realized bankers are what saved the day. And I'm going to tell you, in our Chamber of Commerce, we got some great bankers. In your Chamber of Commerce, I bet you got some great bankers that care about you and know what they're doing. But these community bankers and bankers that paid some attention to business, they are the ones that by being able to streamline to the extent it was possible, this SBA CARES Paycheck Protection Program, they saved the day. There are businesses operating, and I'm one of them. I am not ashamed to admit my bankers and that cushion, because I got to tell you this, you want to make progress on your spiritual path, ladies and gentlemen, you just see your receivables for one go down by 50%. You will be talking to every deity you ever heard the name of before that day is over. Things are better now. But okay, insurance policies. Chase a Rooney. I bet you there are some great advisors about insurance and securities and financial advisors. And where is insurance and where is financial advice? Those are different licenses, but you really need to have someone who holistically approaches your wealth and tells you what to do. And I bet you got great ones in your chamber, so go get serious about insurance. Auto, general liability, annuities, succession planning. My favorite, CPAs. Now, some people think they can just get their nephew to keep plugging into that spreadsheet and then go over to TurboTax and let her rip. All my career as a business owner of multiple businesses, not just a law firm, I have always paid a lot of money to CPAs, and they have always saved me more than whatever it is I spent on them. So what do I care? It's just gravy, and you get it done right, and you're not audited. A CPA stamp is, Mr. IRS, you need to put me at the bottom of the stack. That's absolutely true. So there we are, back to the most attractive human beings on earth. Our chair, Go Chase, and our executive director, who cannot be with us today because she is tended, very needed by her family in Nevada. And Tina, if you're listening, we love you. But I just want to conclude by saying one thing. I have many wonderful friends, and I do work in many capacities with many different chambers of commerce and trade associations, and most of that I do pro bono. Chase, you're not the only one, but I've always been frank about the fact that there were some others. But no one has ever shown this law firm more courtesy, more support, more love, and equally important, has more just plain fun at their meetings than the Austin LGBT Chamber. It was this ridiculous. I was dubious, Chase, about this having a cocktail party on a webinar. I don't even drink. So it was just ridiculous. But, this lifting a glass in to my two-dimensional friends, and it's just wonderful. We're a fun chamber. And if you're listening today and for some reason you're not part of a chamber, you don't understand the nuances and the wonderful fellowship, friendship, and strength, as well as valuable information that you will derive if you just go join the chamber, the LGBT chamber that is nearest to you. And also, I want to conclude where I began. Somebody like Laura Fowler, or for that matter, you, Chase, probably wouldn't be rejoicing about this decision on Monday if it hadn't have been for a huge activism by these chambers and other groups that are similarly related. There are many groups that work together. Huge political action committees. You know, what goes into filing amicus briefs and the expense and the skill of the lawyers. In this case, it was technically the ACLU that was the lead counsel, but there were enormous, complicated efforts by many, many groups. That takes support by every one of you. Every one of you does not need to write a check for $100,000. If you do, yahoo, I'll come over and do a lap dance for you. And at my age, what'd you say I am, Chase, 124 now? That might be worth the price of admission. But for everybody else who doesn't want Laura Fowler to do a lap dance, if you just show up and support your chamber. When elected officials come over and talk to us, and we got in Austin, I was so proud the last time that happened. We had 100, the day after a holiday, we had 110 people. We could barely breathe. That was before coronavirus, obviously. 110 people, we could barely breathe. That means something. And every one of you in every one of your cities, I hope you have the same kind of power and support that we do here in Austin. If you don't, you just come see this man right here, and he'll teach you something about support and activism. Chase, you are an inspiration to me every time I come to one of your meetings. So thank you. And ladies and gentlemen, a religious experience. The old trial lawyer actually, I knew I had an hour and a half, and I only hogged 7 minutes more than I was told to spend. So I'm through.
We weren't allowed to have her lunch until she quit talking. So we're
done.
In all seriousness, thank you, Laura, for your advocacy for advocacy. A lot of people are feeling a lot of motivation these days to get involved and do something about the broad and sweeping and overdue and important social movements that are happening. And I think it's really important to remember that things like Supreme Court decisions or laws getting passed or folks getting elected, those are simply the markers of a lot of hard work by a lot of people that went on for a long time. And what we need you to do is get involved, whether it's with your local advocacy through the chamber or through another organization that we can help you get plugged into. We need you to do more that lasts a long time to help get involved. And it's more than just giving money. It's giving your time and finding out what gifts you have that you can put towards the cause that are going to last longer than a news cycle, that are going to last longer than an election cycle. Put your money where your passion is and your time where your passion is, and get involved and stay involved. After that brief commercial, thank you, we're going to open up for questions. And if you will, type your questions into the Q&A box. And Laura, we've already got one. For those of you not in Austin, I don't know the status of other cities, but our mayor just put out an order requiring masks for the workplace. So the question is an employer liable with the new mask order if they do not require staff to wear masks with the new mask order if staff is less than 10? Also, what is an employer's liability if they have employees come back to the office right now and then they catch COVID-19? Can they blame their employer for it? Can they sue the employer?
Okay, that is the ultimate question. And I, as a trial lawyer who's defended a lot of employers, I don't believe it's possible in most instances, will be possible in most instances with the deep penetration of this disease now to even prove it up. I mean, you can't just say, I got sick, somebody up here had coronavirus, so I caught it in the workplace. Now, remember, when we say employer is liable, and this is something to be thinking about, Texas is what's called an elective state for workers' compensation. There are a few exceptions to that are governmental units and a few by collective bargaining agreements, but mostly in Texas, an employee, regardless of size, is not required to have workers' compensation. However, most employers do carry workers' compensation. So if an employee becomes ill, that's the path they're going to go down. It's really no different than if they come in and say, I broke my leg while you were asking me to move a box. Well, they don't just get workers' compensation because they broke their leg. They've got to prove up that the producing cause of their broken leg was something in the quote unquote scope and course of their employer's duties. And the same is going to be true with coronavirus, only with breaking your leg because you moved the box, that's a whole nother animal from trying to, because the proof burden is on the employee. So
I'd like to add that in most cases, being a licensed insurance professional, in most cases, coronavirus is going to be covered by your disability insurance. Whether it's personally owned or whether it's provided by the employer, someone gets sick from coronavirus, likely they have a disability insurance claim. Because simply put, it means you're too sick or hurt to work, no matter what the cause, whether it happened on the job or not. That said, you need to be very conscious of what the waiting period before benefits start is, because if you have a 30-day waiting period and you're covered in those 30 days, you don't have a claim. Sorry to interrupt. That's just
no, that's excellent.
Practical aspect.
That's a very good point, that there are, unlike other types of claims, there are a lot of buffers that afford at no cost to the employer, other than the cost he's already assuming. Healthcare is the first. You don't have a duty to have health care in Texas, but if you have health care, that's the first buffer. Then the second buffer is disability. You don't have a duty of disability in Texas, but many employers do. So that's the second buffer. The third is this dollar for dollar credit against the payroll tax. So that's the third buffer. So there's a lot more before it ever gets back to the employer. But the employer liable, I just cannot imagine the proof problems the typical worker is going to have proving that up in all but the most extraordinary of circumstances.
So Laura, let's talk a little bit about the mask rules. And if I have an employee who refuses to wear a mask, what are my options?
Well, you know, now this one, and this we talked about a lot in our last webinar, which is this is not a uniform rule at all. The governor has said no one may be fined and it is optional. However, as of this morning, and it has nothing to do with the governor's order, because the governor gave his order but allowed further rights to counties and cities. That would be your mayor by executive order or your county judge. So you just got to go read the rule. But my understanding, I haven't seen it yet, it was issued early this morning, is it is a fine. The city of Austin may fine up to $1,200 for refusal to wear a mask. And maybe some of you high rollers out of there, that's a so what figure, but to me, that's big money. So the consequences, now let me say one other thing, and this is quite a significant point. To whatever extent, and this has nothing to do with coronavirus, this is a fundamental of liability. To whatever extent, whether you're an employer or a building owner or control of premises, you violate a law. In this case, the mayor's order is a criminal law carrying misdemeanor consequences and a fine. Once you violate a criminal law that's a misdemeanor, it takes you into a different proof setting, which is by the violation of a law, the burden of whoever it is claiming something you did because you violated the law caused them to be injured, their burdens become far fewer. Now that sounds like a bunch of lawyer jibber jabber, and it is, but it is very important jibber jabber when you get over to the courthouse. So my point, I think the average employer, the average worker would have a difficult time proving it up. Somewhere where the employer just steadfastly said, nope, we're not wearing these masks. I think it's stupid. At that point, since in the city of Austin right now, that's violating the criminal law, the worker's ability to prove up would be considerably, the burden to prove would be considerably less. So I would not, you know, this will pass, friends. You'll be thinking about it the rest of your life, but this whole mask business. I kind of like it. I've got my tailor. My tailor, by the way, is an LGBT chamber member in Austin. Victor, if you're out there listening, sartorial splendor. I think that's, and just look at my suits. You know, I'm just really a sack of potatoes here. And then with these suits, I bet you're thinking I'm a pretty cool looking lawyer. And all my ties match all my masks. And if you get yourself a custom tailor who's a member of your LGBT chamber, like Victor is, you just look like $1 million. But in any event, I think everybody, at the expense of somebody thinking you're a weenie, ought to wear their masks and do what these judges, these county judges and mayors are telling you to do. Not because you necessarily believe in it, because there's a lot of scientific evidence now that is beginning to suggest there's a bunch of nonsense, that we don't know what coronavirus is 4 months into it. But whatever it is, I do know what's going to happen down there at the district courthouse if somebody gets sick and you were the employer or the supervisor who said, I don't care, we're not doing it. This is Texas and we're not going to do it, even though the mayor in this case, or your mayor or your county judge. But that's a long-winded way of just saying this. Get that order of your mayor. Figure out where you are, okay? Because not all localities have the same orders, and figure out what it says. That's a very good question, whoever asked that.
And on top of that, speaking not as an attorney, but as a Chamber of Commerce representative, it's just good business to have a mask with very few exceptions. So if you've got guff from clients, customers, or employees about requiring masks, not only can you fall back and say, look, that's the law right now, but you can also say, I'm not just doing this for your protection, but for mine and for the protection of our customers, our clients. You want to keep getting a paycheck? It's good business to have good hygiene and take good care of everything we can do to stop the spread of coronavirus.
That's exactly right. Because you go down there to courthouse with that one, and you can turn to the jury and you can turn to the judge and say, I follow the CDC or the mayor's order to the letter. What more could I have done, Your Honor? And that's a lot more powerful.
Fairly indisputable defense.
Yeah,
well, Laura, we have another question. Any recommendations on how to navigate an employee saying he or she does not want to return to the workplace due to their anxiety in correlation to COVID-19 making it worse?
Okay, this is my favorite question to answer, Chase, and whoever asked that, because it's a sequence, and it's a very important sequence. And it also, what Chase just said, that scenario has played out in HR offices and in the boss's office for about 2 months now. And I don't fault or judge those people who are truly frightened. You just watch the TV set. I confess, I'm addicted to TV news. It has never been better. It's never been more frightening. Who needs scary monster movies when you got Fox and CNN and BBC all day? You know, all gonna die. But so people, rational people, are probably very afraid because they're rational people. But here's the way it works. And some of this has nothing to do with coronavirus. But you got to understand this. Whether you have one person or 500 people in your employee, you are governed by the Americans with Disabilities Act. Now you're wondering, what does that have to do with what Chase just asked? I'll get to it in a minute. But someone who comes up and says to you, I have coronavirus, so I want to stay home. Or let's not even pick coronavirus. Let's pick some other disabling condition. I can't work now, but suppose you don't think it's a disabling condition. Well, if someone doesn't have a disabling condition, they have to come to work. And the Americans with Disabilities Act mandates that employers make those accommodations that are quote unquote reasonable. And reasonable, if you're heavy construction, is different than if you are a historic research archive. You know, reasonable is in light of what you do and how you generate revenues. But here's my point. When someone comes up, and I think you ought to be extraordinarily kind to these people, whether you employ 500 people or 5, you need to go beyond the minimum that you must do. And when they say, I am afraid to come to work, that in and of itself is not anything that fits into coronavirus. But if they really have such severe anxiety that it meets one of the definitions of temporary mental illness, they should go, they shouldn't just be suffering and afraid, they should go get some help. And you should tell them, we've got a wonderful health care plan, go get some help. You can get whatever you need from this healthcare professional, and then if he concludes whatever is troubling you makes you unable to work right now, then fine. And we will treat you as temporarily disabled and we will move on. We will see, due to your disability, if we, in what we do for a living, can make a reasonable accommodation. Now, that isn't what everybody's talking about with this coronavirus, but I'll bet you every one of you who's got an employee handbook has got an Americans with Disability Act mandate. You should right there in your handbook. You always have to be thinking, how is whatever they're saying is wrong with them or frightening them actually fit into some entitlement to stay home, or, to be blunt about it, is just a bunch of nonsense because it's more fun to stay home than to get up and brush your teeth and comb your hair and go to work every day. And for every one of these people, it's a different question. But do not pick and choose on the basis of who you like and who was a good worker and who wasn't. It really needs to be based on whatever disability manifests, and then they get the help and the diagnosis they need. And you don't need to be sitting there guessing whether they're ill or not. It needs to issue from a medical professional. If they don't want to go to a medical professional, well, just like with workers' comp, you don't decide if they've injured themselves so much they can't lift 20 pounds anymore. A healthcare professional does. That's workers' comp 101. And this is quite simple. It's not going to be simple because they don't want to come to work because they're frightened. But that is the sequence. And it
Laura,
sounds in American.
If I'm a small mom and mom or pop and pop organization and I don't have a group health plan and don't offer those benefits, okay, what then would you recommend? Do I need to send them to their primary care provider? Do
yes,
I? Okay.
Absolutely.
Okay.
Whether it's they got injured on the job or they're afraid to come to work or whatever, you don't.
It all stems through the ADA. What if their healthcare professional comes back and says, there's really nothing wrong with you. I understand your fear, but it's not a diagnosable medical event. You're perfectly healthy to work.
They have to come back to work.
And
it's
there's
really,
nothing can be done about it legally.
These things, fear and anxiety and a lot of these other things, they actually don't have a lot to do with coronavirus. They are much more similar, in my opinion, to what we deal with in workers' comp. Let me give you an example with workers' comp. Suppose you're a small employer, you do not have health or disability benefits. Maybe you don't even have workers' comp benefits. But I would hope if someone has been ill and out for a couple of days, you tell them if you're out more than 3 days, you cannot come back until you present a physician's statement that you're well enough to come to work. If they get hurt on the job and they do have medical care, they don't get to come back until the attending physician says they're now fit to resume their duties, or if you want to give them light duty, some of their duties. That's the way to be thinking about it, whether it's purely mental or physical or whatever it is.
Well, and again, speaking not as a legal professional, but as a Chamber of Commerce representative, I think there's also a little bit of middle ground where you're having a caring and frank conversation with your employee about what reasonable accommodations you might be able to make to mitigate their exposure, whether it's mitigation in an office setting or in the workplace setting, or if you're able to provide some way for them to work remotely, if that's even possible. So I would definitely exhaust that option, yes, and see if you can address their fears and concerns in a rational way and get them back to work in a way that they feel safe before you mandate that they go see a healthcare professional because they have anxiety over coronavirus.
Boy, that's a very wise, astute observation, because all of us, now I'm 65 years old, I'm an old buzzard. I can't be trained to do anything. And I was very dubious about this. Everybody go to the house. Our law firm, according to the Austin Bar, is the oldest median age law firm in the city. I have no idea how they figure that out. And that's by design. I mean, look at us. Those are the best looking buzzards you've ever seen, ladies and gentlemen. But seriously, what I now know that I didn't know 10 weeks ago is most of what we did up here, because we just love seeing each other, is actually done better at the house because it's quiet. You can think without distraction. And my point, to Chase's point, there are a whole lot of managers and business owners who have learned that lesson. And if you don't try to make some reasonable accommodation and try and let them work from home, that's going to be whether it's the judge, the jury, you know, the court. Our federal, state, local court systems have practiced 100% remotely. They're now starting to come back online. I got 16 lawyers, most of them are trial lawyers up here. We haven't seen the inside of a courtroom in 10 weeks. And it all worked pretty well, other than a few things like eviction. So my point is simply this. Almost everyone now believes that a whole lot they never dreamed they could accomplish with people working remotely is not just possible, but possibly better. And for that reason, what Chase just said, that's a very important thing to think about. Because you need to be able to answer to a court if you say, no, you're coming to work. The court will ask you, opposing counsel will ask you, why couldn't you give that person the opportunity to work from home? So many employers, who is it now, Apple, that says 80% of their workforce is not coming back? I mean, just staggering sums of brilliant, highly compensated people who aren't going to be brought back into the, I mean, it's just astonishing how many people are not going to come back because they don't want to and they don't need to.
So we have one more follow-up question and then we're out of time. If you do have someone that you refer to, a healthcare professional for that disability certification, do you recommend it come from your EAP professionals, from your employee assistance professionals, or from their own healthcare professional? And I'll take a stab at a short answer. It doesn't matter as long as it's a healthcare professional that does the certifying. Mm-hmm. If the EAP is going to be easier, cheaper, faster access for your employee, that's great. If they're not comfortable with that for whatever reason and want to go see their own healthcare professional, that's going to be sufficient to get their claim that they need.
Yeah, can I add one thing to that?
Absolutely.
And that's very important what you said. There are some physicians who are great physicians, but they just have no idea what an occupational evaluation is. Because now, whether you're sick or well, and a therapeutic path is an entirely different evaluation than with what you've got and with what this employer does. And, you know, if you're going out and drilling pier and beam or driving the dump truck, that's different than making pastry cupcakes. So whatever it is that is troubling your employee has got to be evaluated in terms of whatever it is that goes on in the workplace, and then whether or not they can work from home, is it reasonable, and all that. So Chase is absolutely right. It needs to be a physician. And, you know, sometimes the employee just shows up as if he's going over there because he has a cold or a flu, and then says, I got to have this statement of physicians. I have this happen a lot because I tell my employee, don't let them come back until they have a certification from a physician that they're fit to return to work. And more specifically, they're fit to perform the duties for which they are employed. And a physician is a great physician, but they have no idea what to do because that's just not what they do. So yeah, it would be preferably if they've had some experience doing that. And have the employee take a form with them, your form, so you get the right questions answered.
So with that, we're running out of time. I would like to thank everyone for their questions and for sharing this hour and a half with us on a Thursday when everybody's probably a little zoomed out for the week, but this has been really informative. I'd like to point everyone to thefowlerlawfirm.com if you have questions, comments, personal experiences for Ms. Fowler or anyone in her extremely competent team. I can attest that she is just as entertaining one-on-one as she is in a group setting, and just as knowledgeable if you have questions for her, she does do free consultations, and she's very, very happy to support members and friends of the LGBT business community. One more time, I'd like to invite everyone to our Supreme Court Title VII discussion, panel discussion, Monday evening at 5:30. The link for that event is in the chat window. And please, if you're not a member of your local chapter of the Texas LGBT Chambers of Commerce, please join, reach out to the leadership and talk to them about your business. Let them get to know you and brainstorm how your business could benefit from being a member of that chamber. Because I can guarantee you, if you care about LGBT rights and you're in business or even business adjacent with your organization, there's a role for you to play, and a role that the chamber can play in your organization as well. With that, thank you, everyone. We really appreciate your attending. Stay tuned for new events. And if you have any further questions, contact the Austin LGBT Chamber, the Fowler Law Firm, or your local LGBT Chamber of Commerce. Thanks again. Have a great day.
Thank you. Bye-bye. Come see us.